Hi. Hello, everyone. Thank you for joining us this evening. My name is Andrew Henderson. I'm the audience growth producer for the Lexington Herald-Leader, and I'm joined this afternoon by Alex Acquisto, our health and social services reporter, here to talk to us a little bit about Amendment 2, which is going to be on the ballot of every Kentuckian coming this election day. Now, Amendment 2 deals specifically with abortion rights and access here in the Commonwealth. And Alex is going to graciously give us some of her time to tell us a little bit about it. And before we sort of dive into that, Alex, just wanted to ask you about sort of where Kentucky is right now, with abortion rights and access. I think when we last spoke about this particular issue, it was before the Supreme Court had issued a ruling sort of overturning Roe v. Wade. And then in Kentucky, that meant that a trigger law went into effect. And now there are some sort of legal issues surrounding that, it being tied up in court, things like that. So if you could just sort of kick us off by telling us a little bit about where sort of Kentucky stands right now as far as abortion access goes, and what this trigger law has done, and sort of where all of that stands. So I'll throw it over to you, Alex. Thank you.
Sure. Thanks, Andrew. And thanks, everybody who's watching. So basically, for those of you who don't know, I'm assuming many of you do, but for those of you who don't, when Roe versus Wade was overturned by the U.S. Supreme Court in late June, Kentucky had ready a trigger law, which was the product of a 2019 law, which was passed under former Governor Matt Bevin, basically waiting in the wings to be enacted in the event that Roe was overturned. Our trigger law, like 13 or so other states, includes some exceptions. Basically, the only exceptions, so basically, the trigger law in Kentucky bans abortions in all cases, with the exceptions being if the life of the pregnant person is at risk, or if the pregnant person needs an abortion to avoid basically injury to a major bodily organ. So there are only medical exceptions to Kentucky's trigger law, and even those medical exceptions are limited. There are no exceptions for rape or incest or fetal anomalies, really any conditions that would make a fetus not viable after birth, but might not in the immediate put the life of the pregnant person in danger. So when Roe was overturned, Kentucky's trigger law locked into place immediately. Abortion essentially became banned overnight. And I think Roe was overturned on a Friday. The following Monday, our two outpatient abortion providers, Planned Parenthood and EMW Women's Surgical Center, sued the state over the trigger law, arguing that under the Kentucky Constitution, as an extension of our right to privacy, abortion is a protected right, which under the federal Constitution for 50 years, Roe was founded essentially by justices in 1973 as being an extension of the federal right to privacy under the federal Constitution. So basically in the months since, there's been a series of legal volleys back and forth. A circuit court judge in July granted a temporary restraining order, which basically suspended Attorney General Daniel Cameron's ability to enforce the trigger law while it was winding through courts. Separately at play here, Attorney General Daniel Cameron, who's a Republican and running for governor, has been pretty dogged in his pursuit of wanting to enforce the trigger law, and he has really fought hard against the ability to do that. So the trigger law was suspended, I can't quite remember the timeline, in the summer, and then he challenged it to the Court of Appeals and the Kentucky Supreme Court. Both of those higher courts initially dismissed his request and upheld the lower court. Cameron then appealed to the Kentucky Court of Appeals, and in early August, I believe, they granted his request, allowing him to enforce the trigger law and again meaning that abortion was banned in Kentucky. So our trigger laws basically length of effect has been in fits and starts, but consistently since early August, abortion has been banned in Kentucky. Coincidentally, as Andrew said, we happen to have a ballot question on this November's ballot in the midterm election, which is the product of a separate Republican-backed bill that was passed in 2021, which asked voters if they want to change the Kentucky Constitution. And Andrew, if it's okay with you, I can go into that also. I have it up here on my screen. I'm sure many of you listening know what the question will ask, but for those of you who won't, this is word for word what you will see on your ballot if you go into a voting booth in Kentucky on November 8th. You'll be asked to answer yes or no to the following. Are you in favor of amending the Constitution of Kentucky by creating a new section of the Constitution to state as follows: to protect human life, nothing in this Constitution shall be construed to secure or protect a right to abortion or require the funding of abortion? It's kind of a confusing question. It seems to the point, but its impact, I think, is confusing, which is why we're having this little forum to talk about it. Essentially, that question, separate from the trigger law, does not equal an abortion ban. But what it would mean is that in the same way that U.S. Supreme Court justices in 1973 interpreted a right to abortion as an extension of the right to privacy under the U.S. Constitution, Kentucky's Constitution is very similar. The argument that, as I said, Planned Parenthood and EMW, the ACLU is their representation, they are arguing that Kentucky's Constitution includes a right to privacy and a right to bodily autonomy as an extension of the right to privacy outlined in our Constitution, if that makes sense. So by adding these words to the Constitution, it would make clear that there is no protected right to abortion in Kentucky under any circumstance, or the funding of abortion in Kentucky. All that means is that because Kentucky already has a slew of restrictive abortion laws on the books, the most predominant being our trigger law, which bans the procedure outright in most cases, this change to the Constitution would basically eliminate the possibility to challenge one of those laws in court, if that makes sense. Andrew, feel free to jump in if you have a question or something. So a change to the Constitution does not equal a ban, but it would make it very hard to challenge and for a court to find a right to abortion within the Constitution if somebody should, say, challenge one of Kentucky's abortion laws. That's already happening, as many of you know, and as I just outlined. And so this constitutional amendment comes at, coincidentally, a very pivotal point, which is that before the Kentucky Supreme Court, now there is this legal challenge to the trigger law, and Supreme Court justices a week after the election will start hearing oral arguments on this case, which is, essentially challenging the constitutionality of a ban on abortion. So there are two separate things, and it's quite complicated to suss out. And then, Andrew, I don't know if you want me to get into the sort of campaigns to pass and defeat the constitutional amendment and kind of the messaging behind what they're doing.
Yeah. So first, for those of you who may be joining us just now, we were here, the Herald-Leader. This is the Herald-Leader's Health and Social Services reporter, Alex Acquisto, sort of breaking down Amendment 2, the ballot question for this November election here in Kentucky that pertains to abortion rights and privacy. And as we've sort of heard so far, when Roe v. Wade was struck down, a trigger law took effect in Kentucky that sort of, that more or less banned abortion in many, if not all, circumstances outright. There's been some legal volleying back and forth over that, but as of the most recent sort of legal case in that, abortion is, for the most part, banned. The procedure is banned here in Kentucky. And Amendment 2 is sort of, and maybe Alex, you can speak a little bit more to this. It sounds like Amendment 2 would, if it passes, would sort of be perhaps a sort of like legal or judicial backstop to say that, if you wanted to bring some sort of, legal case, pertaining to seeking an abortion or something along those lines in the state of Kentucky, that you're sort of out of luck because the state constitution would not allow for you to do that. Is that sort of an apt description, or can you correct me if I'm wrong on that?
No, I think that's right. So, I was reading yesterday, we've seen stories of women in other states who are pregnant who have been denied abortions for varying reasons because the reason that they need an abortion, it might be medical, does not fit under the parameters of their trigger law. I was reading a story last night about a woman in Missouri whose water broke early, essentially, and her life was not imminently in danger. So under Missouri's trigger law, she could not legally get an abortion, even though the fetus was not viable. So she had to travel out of state. She was planning to sue the state over the trigger law because she was denied care when it was medically necessary. If that were to happen to a woman in Kentucky and she decided to sue the state over basically how she was treated under the trigger law, a constitutional amendment would make it very hard for a court to interpret that she had an inherent right to abortion under the Constitution if it came to that point. If that makes sense, Andrew. So in and of itself, it's basically another step to restrict access. In this country, in this state, we have three branches of government. The judiciary, our court system, essentially functions a lot of times as an arbiter of our lawmakers. In Kentucky, the different court system basically are occasionally put in the position to hold to account people who make laws, and the constitutionality of laws are challenged all the time. If the Constitution is changed, this would remove that ability, that oversight ability that courts have. And in doing that, it would give the General Assembly greater power, because it essentially means that without courts' ability to interpret a right to abortion in the Constitution, it means that lawmakers, and in Kentucky we have a Republican supermajority, lawmakers are the sole arbiter of abortion regulations in the state. So the argument on the side of lawmakers who support the amendment, which are primarily Republicans, is that they don't want activist judges, pro-abortion rights judges, basically making a local version of Roe versus Wade in Kentucky. Conversely, the opposition is saying, this removes the ability to hold lawmakers to account and basically emboldens this body that has really highly prioritized passing restrictive abortion laws in 2016. Since 2016, we've passed more than a dozen, if I'm remembering correctly. And so it's yet another sort of mechanism to limit access to abortion. Again, slightly different from banning it outright, but we already have a ban. So again, changing the Constitution means that any legal challenges to existing abortion laws in Kentucky, and we have a trigger law in place that bans abortion, except in cases of medical emergencies, any legal challenges to those on the basis of, abortion is reproductive health care. I have access to it. a court will have a harder time finding legal room to interpret abortion as a right if the Constitution is changed. Does that make sense?
Yeah, absolutely. Thank you for sort of explaining it in that way. So it's not so much that, if the amendment passes, it would be tantamount to an abortion ban, because in Kentucky that already exists. But it would sort of provide, or it would sort of result in another sort of stepping stone, in a sense, of curtailing the rights to that procedure. Um, and Alex, you had mentioned, you had touched on a little bit about the groups that are very much, involved with some of the fundraising of this campaign on both the yes and no side. And I do want to talk about that, but something I do want to ask you about, and it's something that have gotten some questions about from social media and from email as well. But some readers are wondering exactly, I suppose, in just layman's terms, because these amendments, these ballot questions can be worded in a way that can come off as a little bit confusing. So can you explain exactly what, a yes vote and a no vote on this amendment sort of means for voters who are going to be going to the polling places, come November? What does a yes and a no vote mean on Amendment 2, essentially?
So right now, the Kentucky Constitution does not mention the word abortion. A yes vote on question 2 would add a paragraph to the Constitution of new words, making it clear that, quote unquote, nothing in the Constitution it should be construed. Basically, nothing in the Constitution guarantees or protects the right to abortion. So a yes vote would be, yes, I literally want to add these new words to the Constitution. A no vote would keep the Constitution as is. A no vote would not do away with Kentucky's abortion ban. That is the result of a separate law, but it would basically maintain the status quo and keep the Constitution as it is right now, which does not mention the word abortion. By voting no in extension of that, as opposed to if you voted yes and added those words to the Constitution, it leaves a certain amount of freedom for courts that receive these legal challenges by people filing lawsuits against the trigger law, for example. It leaves room for them to interpret the Constitution with more flexibility. By not explicitly mentioning in the Constitution that there is no protected right to abortion, you could, as a Supreme Court justice, conceivably interpret that under the section of the Constitution that protects right to privacy, for example, you could conceivably interpret that abortion is a protected right as an extension of one's right to privacy. So a no vote means that the status quo of a Constitution that does not mention the word abortion would stay the same. A yes vote would literally add a new paragraph to the state's Constitution, making it clear that there is no protected right to abortion, which is only relevant, essentially, if it's challenged in court, if that makes sense. So let me just add this too. A yes or a no vote, even if the amendment fails and even if it passes, the trigger law will still be in effect. So abortion will still be banned regardless, because that is a separate law.
Okay. Yeah, thank you for that explanation. I think it can be sometimes, if you're going into the voting booth and you're not necessarily aware or prepared for some of these ballot questions, that the language of it, the sort of concepts behind it may come off as a little confusing. So I appreciate that breakdown of sort of what would a yes or no vote entail. And something you had touched on earlier are these sort of these two driving forces campaigns here in the state, both behind a yes and a no campaign for the amendment. Could you speak a little bit to that about sort of what you're seeing out there about what these two campaigns are doing and trying to influence that vote one way or another?
Definitely. Because, so basically we have two campaigns, as you mentioned. Protect Kentucky Access, which is a campaign working to defeat the constitutional amendment, which means that they are advocating that people vote no. They are against changing the Constitution and removing that protected right to abortion. On the other side, we have a campaign called Yes for Life, and they are advocating for a yes vote. Yes for Life is largely funded by religiously affiliated groups, the Kentucky Baptist Convention, Catholic Conference of Kentucky, Family Foundation, and they put out their first TV ad yesterday. They have raised, I think, $620,000-ish. They are basically being, in terms of fundraising, Protect Kentucky Access has raised almost 5 times as much money over Yes for Life. Just as we saw in Kansas with their referendum on a similar issue, Yes for Life is Protect Kentucky Access is getting funding from major national organizations that you would expect: Planned Parenthood, the American Civil Liberties Union, and they've raised just over $3 million. They've put out 2 TV ads. The messaging here is quite interesting. As I just explained, even in explaining it, I feel like I talk myself in circles a little bit because it seems simple, but it's complex a little bit. And so in thinking about if we are a campaign wanting to inform voters of how to vote in a specific way, how do we simplify this message? Abortion is an extremely socially divisive issue. If you're working with, say, 30 seconds of ad space on a television, you have to basically present a really digestible message in a short period of time. And so what both campaigns have done is basically, one more so than the other, conflate what the constitutional amendment would do and what the trigger law has already done in Kentucky. So Protect Kentucky Access, for example, has really leaned heavy on asking voters if they want abortion banned in Kentucky. Even though the constitutional amendment will not ban abortion, as I said, but it is an extension. And as I said, it's the product of a law from Republicans. That's part of this sort of mobilized effort that has been successful over the last 6 or 7 years to eliminate access to abortion. And so they're purposely conflating the trigger law with the constitutional amendment. If you don't want abortion banned in all circumstances, if you don't want a trigger law that does not include exceptions for rape or incest, you should vote no on the constitutional amendment. It's a digestible message. It's not exactly not true, but they sort of don't go as far as sort of parsing what one does versus what the other does. Yes for Life has leaned more into, at least publicly, relying on more misleading, inaccurate information. In the TV ad that aired this week, it starts by asking viewers if they want to stop radical out-of-state activists. Basically, it tells them radical out-of-state activists want to spend your tax dollars on late-term abortions, even up to the moment of birth. It's a snappy buzzwords that will get somebody's attention because they hear late-term abortions, radical out-of-state activists, taxpayer-funded abortions. It's an easy way to get viewer attention. Most of that is not true. There are no taxpayer-funded abortions right now in Kentucky. Through a combination of federal and state laws, there haven't been taxpayer-funded abortions in Kentucky in I don't know how long. The state legislature passed a law earlier this year, another omnibus anti-abortion bill that added a lot more restrictions to how abortions have to be documented, abortive procedures. It bans, the mailing of abortion pills. It added a certification and monitoring sort of red tape to this, to basically dispense this type of healthcare. And it also, again, made clear, codified into law, that no public agency can pay for an abortion. So both are, kind of purposely conflating what the constitutional amendment would do. But again, Protect Kentucky Access is more rooted in fact than Yes for Life has been. But again, it's sort of very different arguments. Yes for Life has relied heavily on sort of courting the religious right. They had a rally in early October that was attended by a lot of church groups. All of the speakers were ministers, and church congregations have been talking about it. I've seen vote yes on 2 signs in some churchyards. It's very much receiving a push from religiously affiliated groups. Many, conversely, on the other side, Protect Kentucky Access. Physicians, a lot of physicians in Kentucky are throwing their weight behind that campaign. Close to 90 have donated money, personal money, to that campaign. So it's really interesting to see the tack that both are taking. And of course, even though Protect Kentucky Access has the financial leg up, that doesn't always translate to voter turnout, as my colleague Austin Horn and I have written. And in Kentucky, we haven't seen a sort of sustained bump in voter registration post-Roe falling that other states like Kansas have been. So all that is to say, these 2 campaigns are working sort of doggedly in their respective ways to get out their message, but still a lot of people don't know what Constitutional Amendment 2 is. Probably most people, I think it's safe to say, won't know what it is until they see it on the ballot when they're voting.
Thank you for sort of breaking down those 2 campaigns, Alex, that are working on the constitutional amendment, both yes and no. You've mentioned that, a little bit after Election Day, depending on, if this amendment passes or not, there are also elections being held for, Kentucky Supreme Court justices as well. So, any sort of insight or idea how, whether the amendment passes, how is this affecting other races around Kentucky, especially for those Supreme Court seats?
Certainly. So one of the people vying for a seat on the Kentucky Supreme Court right now is running to unseat incumbent Michelle Keller, is Joe Fisher, who was lead author of the constitutional amendment that everybody is voting on. He's a Northern Kentucky Republican. He's a staunch anti-abortion state representative. And again, he's really playing, even though the Supreme Court races are, supposed to be nonpartisan, he's really playing into this kind of avenue that he's carved out for himself as a staunch anti-abortion Republican. As I mentioned, my colleague Austin Horn reported earlier this week that even if Joe Fisher wins a seat on the Supreme Court, he still won't be a part of the court that ultimately decides on this case that's before it, the challenge to the trigger law, whether it's constitutional under Kentucky's Constitution. Fisher would not, if he's elected, be on that court that is deciding that. But you sort of touch on, when you ask me, you sort of touch on this larger issue, which is that this constitutional question aside from being actually very consequential in the future of abortion access, because it would make it very hard to legally challenge Kentucky's restrictive abortion laws. Voters have never quite had an opportunity like this to, short of, electing state reps and senators who either support measures like this or don't. We've never had a direct role in getting to vote on something abortion related before. And it's coming at, a time when the stakes couldn't be higher, a few months after our abortion ban went into effect. And really, as I wrote earlier today in our Bluegrass Politics newsletter, beyond it just being an actual referendum, it's also functioning as a referendum on whether Republicans' tack on abortion legislation has been too extreme. I think that if the constitutional amendment falls and voters reject it, it'll send a message to our supermajority Republican General Assembly that, as I said, has passed more than a dozen laws in the last 6 or 7 years restricting access to abortion in some way. Kentucky, more so than other states, has been very aggressive in that way. And again, voters have never really had quite a chance like this to have a say. I wrote a story earlier this year about the sort of, palatability of abortion laws among voters broadly. Whether most voters think that abortion should be restricted, but there should be, common sense exceptions, or there should be exceptions for rape or incest. There should be exceptions for children who are sexually abused and impregnated. All of those feelings are sort of culminating with this constitutional amendment vote. Either way, lawmakers are obviously paying attention to how voters cast ballots on this referendum, and it will inform, I think, how they move forward and if they need to back off a little bit when it comes to passing restrictive abortion laws. So it's as much a referendum on the playbook that they have been adhering to as it is one that will have actual consequential effects on abortion access in the state, if that makes sense.
Yes, absolutely. Thank you so much for that. I think we've covered a lot of ground here this afternoon, and I was wondering if there was anything else that we may not have, or I may not have asked you about or touched on, or anything that you think would be important for voters out there to know before they go cast their ballot this November.
I don't think so. I mean, the biggest thing that I always suggest to people is there's so much disinformation on abortion and abortion access generally. It's extremely easy to get lost in that sort of tidal wave of misinformation. So many people have opinions on it. Even if you see a political ad on TV, don't automatically assume that it's true. But there are credible places to go get information. I think that when you see, politicians and political ads, political campaigns using ads that include buzzwords like late-term abortion, for example, I just think it's easy to feed into this misinformation. One of the reasons why, we as a country are still have not really found ground to see eye to eye on this issue, which is so socially divisive, is because it's very personal for a lot of people. And so I say, if you have questions, read your local newspaper, read a trusted national newspaper. All of those reporters are on the ground. Yesterday, when Yes for Life aired its TV ad, and I keep mentioning this just because it's top of mind because it happened yesterday, as a local reporter, I was able to see, Yes for Life mentioned late-term abortions, taxpayer-funded abortions. I was able to debunk that fairly quickly because, as a local reporter, I know where to find sort of data, and I can, tell you in real time that in Kentucky, since 2017, so-called late-term abortions, which is usually after 21 weeks, make up about less than 1% of all abortions. If they happen, they are done largely for medical reasons. And so it's easy to, I guess, feed into the low hum of all this misinformation, but be skeptical and sort of know where to get reliable information. But other than that, I don't think I have anything to add. Do we have any questions, Andrew?
I believe the ones that I've touched on already are sort of the same thing. There is one that I think, sort of to even put in even more like simpler terms from a reader, is asking if people who are pro-choice or abortion access, things of that nature, is the simplistic thing to vote no on the amendment, which I suppose the inverse would be if you are, in favor of curtailing that procedure and those rights, then you should vote yes, which I believe you already sort of touched on a little bit.
Yeah, I think if you think that abortion should be a right that's protected, you would probably want to vote no on the constitutional amendment because you don't want those words added to the Constitution.
Right. And that's a very sort of like, distilled, like boiled down view of it. Obviously, I know, as you've talked about, there's a lot more, quite a bit more nuance and complexities to it than that. But that is one question that I did see pop up here.
Mm-hmm.
But I think I really appreciate your time this afternoon, Alex, and I thank everyone who has watched somewhere, wherever you may be watching or listening in. And if you missed this event, you can go back and watch it at Kentucky.com. We'll have the video file sort of there. That's Kentucky.com, also on our Facebook and our Twitter as well. So thank you, Alex. Thank you for those of you who are listening and watching. And go
Andrew,
vote. Yes.
Can I add one thing?
Yes.
I just want to say this, since there are people listening. I think it's important to mention, especially with this constitutional amendment, so much of the dialogue around this issue focuses on elective abortions, which is to say abortions that people choose to have, maybe not for a medically necessary or medically emergent reason. One area that I've reported on a little bit, that other people have reported on, is how restrictions in Kentucky that are in place in the constitutional amendment would make it harder or just impact more is obstetric and gynecological healthcare. Because the fact of the matter is, as I said, I've reported and other people have reported, is that restrictive abortion laws in Kentucky and other states impact routine OBGYN care. It's easy to hear from sort of campaigns that want to push abortion laws, that, even campaigns here in Kentucky or people who want the constitutional amendment to pass say this won't have an impact on how OBGYNs treat miscarriages or ectopic pregnancies. But the fact of the matter is that it is already. Abortive procedures, which again, I'm not talking about elective abortions, but abortive procedures are a routine part of OBGYN healthcare. The way that doctors treat a miscarriage, which is usually, treated with the same drugs that somebody would get to get an elective abortion, mifepristone, misoprostol. All of those things are interchangeable. And I think all of this, as I said, sort of low hum of misinformation and just talk of abortion takes out the nuance, the very real nuance of the actual far-reaching impact that Kentucky's trigger law, for example, and this constitutional amendment would have in those areas. And there are some physicians sounding the alarm. There's no collective voice in Kentucky of physicians sounding the alarm yet. But I think that's one thing that gets swept under the rug is when we tend to talk about these things, we tend to talk about elective abortions. And there's a whole sort of, arguably more consequential area that it's affecting, which is OBGYN healthcare. So I just wanted to mention that too before we get off.
Yes, of course. I think a big takeaway from all of this is that it is, of course, much more complicated than it may seem on its face as to how not only this constitutional amendment, but also how Kentucky's already existing trigger law has affected abortion access, the procedure itself, and the sort of rippling effects that kind of come out from all of this. So thank you for making that point, Alex. And as always, for our listeners and viewers out there, you can find all of Alex's work and our other reporting over at Kentucky.com, where you can find this video as well if you missed the entirety of this conversation. And don't forget to go vote on, double checking, November 8th, Tuesday, November 8th. Make sure to head out to the polls and cast your ballot on that amendment. Another amendment as well, which is Constitutional Amendment 1, which I would be remiss not to mention because there are two constitutional amendments on the ballot. Constitutional Amendment 1 would essentially give our state lawmakers the ability to call themselves into a special session outside of their regularly appointed sessions each year. Right now, that is something only the governor can do, but voting yes on Constitutional Amendment 1 would sort of give the thumbs up and the go-ahead for lawmakers to have that power and ability to call themselves into session. So just wanted to add that in there as well, because there are two constitutional amendments, as well as a bunch of other local races and statewide races. So thank you again, Alex, and thanks for everyone who tuned in today, and get out to the polls on November 8th. Thank you all so much. Have a great one.